I'm Brad Hull. This is a 2-Minute Lawyer. In this video, we're looking at the second part of grandparents' visitation rights statute in Arkansas. In the other video, we discussed who would have standing as a grandparent to bring an action for grandparents' visitation rights under the statute. Now we're looking at, if you have standing, what do you have to actually prove to get visitation rights? And that's also in the statute. As I mentioned in the last video, one of the key considerations here is that there is a rebuttable presumption that the parent's decision to limit contact of the grandparent is in that child's best interest. You must overcome that. That's part of the consideration of the parent's constitutional rights to raise their child the way they see fit. The statute requires that the petitioning grandparent show that they have established a significant and viable relationship with the child, and also that visitation with the child is in the child's best interest. Now, those terms are actually defined further within the statute. The statute states that to establish the significant and viable relationship element, the grandparent must show that either the child resided with the grandparent for at least 6 consecutive months, petitioning grandparent was a caregiver to the child on a regular basis for at least 6 consecutive months, that the petitioning grandparent had regular or frequent contact with the child for at least 12 months, or, and this is the broader one, any other facts that establish that the loss of relationship between the petitioner and the child is likely to harm the child. Under the statute, to establish that the visitation is in the child's best interest, the petitioning grandparent has to show that first they have the capacity to love and give affection and emotional support to the child. Then they must also show that the loss of relationship between the petitioning grandparent and the child is likely to either harm the child, cause emotional distress to the child, result in emotional abuse of the child, or result in emotional neglect of the child. One of the key things here that shouldn't be overlooked is this element says the loss of relationship between the petitioner. And there's some case law out there in courts that have said the loss of relationship language, it matters. There has to be an actual loss of relationship before you can meet your burden of proof on these elements. So if you're still getting contact with your grandchild, you may not be able to meet that element. Lastly, the petitioning grandparent must also show that they're willing to cooperate with the custodian parent if they're granted visitation. And then they must also be able to show that that visitation for the grandparent will not interfere with the parent-child relationship. If they can meet all those elements and they have standing to pursue it, then they have an opportunity to get grandparents' visitation rights. As you can tell, there are a lot of little hoops to jump through here, so they're not particularly easy to establish, but you do have rights as a grandparent. It's important that you know them. And if you're having difficulty accessing your grandchild, then you should consult with an attorney to see what rights you may have.